Hi, good morning. Thank you for joining us today. I'm Vivian Cristino, Capacity Building Specialist at Housing Action Illinois. We are a statewide coalition of more than 160 organizations from around Illinois who are dedicated to expanding and protecting affordable housing. Please note that this presentation is being recorded and will be available for download on our website later on today. Also, I will send you by email the link with the PowerPoint slides. Thank you for participating in our webinar entitled Dealing with Property of Elderly and Deceased Mortgagors. During the webinar, you'll learn about tools to plan for death and or incapacity of a mortgagor, including powers of attorney and transfer on death instruments, process by which property passes at death. We'll cover joint tenancy versus tenancy in common, wills, intestate, succession, and the probate process, also options and strategies for heirs to work with mortgage services to try to assume and modify the mortgage loans, including some federal rights. Our presenter today is Katie Liss, a senior attorney at LAF Consumer Practice Group. She has been working there since 2012. Katie works in the Consumer Practice Group, focuses on preserving homes and other access through bankruptcy, foreclosure defense, and affirmative litigation. Katie is a 2008 graduated from Loyola University Chicago School of Law. We have the handout. It's called the flyer for LAF ADAPT program. It's available, and I encourage for you, if you have clients in Cook County, download the handout because it has information and LAF can help your clients, especially if you are in Cook County. So thank you again for participating in our webinar. If you have any questions, please write your question in the window, and I will be sure that our panelists answer it during the presentation. Katie?
Okay, thank you for having me. My name is Katie Liss, and as Vivian said, I'm a senior attorney in the Consumer Practice Group at LAF. So this is the agenda of what I'm going to be going over today. First, I'm briefly going to talk about how we can plan ahead for our clients that are, aging but still have good capacity. How we can plan, in the case of their death or that they lose their mental capacity. There's a few steps that we could encourage them to take, and then kind of the bulk of the presentation is going to be on the second part, which is how does property transfer at death? What are the different ways that property transfers and when is probate necessary? And then I'll talk a little bit at the end about strategies, for your clients who are heirs of deceased mortgage borrowers to assume the loans and try to get modifications and keep their homes. And I'll address a little bit the different protections that are in place that protect their right to keep the homes. So I'll stop at a few places throughout the presentation to answer any questions. So as Vivian said, go ahead and put the questions in the chat if you have any. So planning for death or incapacity of elderly clients. One instrument that can be a really useful tool is called a TODI, which is a transfer on death instrument. They're new. There's a law that went into place just a few years ago and allowing these in Illinois, and there's only, I think, maybe 10 states or so that have these. But it's a really good way for mortgage borrowers or not just mortgage borrowers, homeowners to plan ahead as far as their wishes on, who should get their property after they pass away, because this avoids the need for probate. Basically, what a TODI is a piece of paper that gets recorded with the recorder of deeds, just like a deed or a mortgage or any other document with the title of the home. And there's a very strict form that you use for it, but it basically allows the title holder of the property to state that in the event of my death, the property should be transferred to this person or this person and this person. They can choose a couple of different people if they want. The cost to do these are, possibly if you pay a private attorney, they would charge you their cost, but then legal aid is often able to do them, and the only cost then would be to record it with the recorder of deeds, which is around $50. So it is important to, have it properly recorded, but executing this simple piece of paper and recording it is a lot easier than, your family members and your heirs having to go through the process of probate. So it's something that I would definitely encourage, any aging clients to consider. One other advanced directive that, might be relevant to your work is the power of attorney for finance. This here is a list of some of the things that a power of attorney for finance can accomplish. So a power of attorney for finance is where the aging person designates one person to act in their place, and it could be, to start acting in their place immediately. They could just say, I don't want to deal with my finances anymore. I'm going to defer to my power of attorney. Or what, probably is more common is that it can be set so that the agent starts to act in the event of the principal's incapacity. So the aging person can say, okay, I'm starting to get older. If it gets to the point where I don't have the capacity to manage my finances anymore, or I don't have the mental capacity to really be fully aware of what's going on around me, this is the person that I'm choosing to be my agent and to handle all of my financial transactions for me. So the person that they designate, the power of attorney can be limited as much as the person wants. So you could say, the only thing that they're allowed to do is access my bank account and pay my bill for me, or my mortgage for me, or whatever it may be. But they can also be broad enough to include all of these things. So it would give the agents the power to enter into real estate transactions, to engage in claims and litigation. And so what this could mean is that if an elderly person finds themselves, in foreclosure or at risk of losing their home, or, in default on their mortgage, the power of attorney might be able to step in and retain, legal aid to help defend the foreclosure, possibly to apply for a loan modification and get information from the mortgage company about, the default and what's needed for the loan modification. So they can be a really helpful thing to have in place, and it's something that you might want to encourage your aging clients to consider. One thing with these, though, is that you want to be really careful to watch out for abusive or exploitative heirs. Unfortunately, there are, cases where, a child is appointed agent by power of attorney and, takes advantage of the elderly person and spends their money, for their own benefit, and doesn't, kind of neglects the well-being of their parent or the elderly person. So you want to encourage, your clients that if they're going to do this, that they're really careful about who they pick. Maybe they're not automatically going to pick their child. Maybe there's somebody else that they trust more. So it's a big decision for someone, and, it's just something to watch out for. So this is the handout that Vivian has already sent to you, but LAF actually has a project right now that provides toadies as well as powers of attorney, and not just for property, but also powers of attorney for healthcare and living wills at no cost to eligible people. So if they're 60 or older and they live in Cook County, I would definitely encourage your clients to call to set up an appointment. We have a special number just for this project, which is the number that's on the handout and that's circled right there. They call, they'll leave a message, and they'll hear back from someone from LAF within 3 business days to set up their appointment. They do have to be able to travel to either LAF's office or one of our clinics, to execute the documents, but the rest of it can be done over the phone. So anyway, I would really encourage your clients to call this number if they are even, considering a toady or power of attorney. If they're not sure if it's something they want or not, if it's something that they're considering, the LAF attorneys will talk them through what it means and what the benefits are. So definitely share this number. And if you're not in Cook County, I would also encourage you to contact your local legal aid with these issues. They might be able to help as well. Okay, it looks like we do have one question. But I'm understanding is that there's a question being asked about whether the power of attorney would allow the agent to act on the, it says on the client, on behalf of the client? Oh, during a bankruptcy. So that's actually kind of a question it's been a dispute within our agency, because if the bankruptcy is already pending, then yes, then I believe that the agent can act on the client's behalf. If it's like a Chapter 13 that was filed and is pending, I think they can act on their behalf. Whether the agents can file bankruptcy for the client is kind of a sensitive topic, and I think it is possible to be able to do that, but there is kind of a heightened standard that you have to apply within the bankruptcy court to do that. But if it's a pending bankruptcy, then yes, absolutely, they can act on their behalf. Are there any other questions about power of attorneys or TODIs or advance directives?
No, they are only asking if there is an income limit for these services.
Yes, so there is an income limit in that they have to be eligible for one of our grants. We have certain grants that, give heightened income limits to individuals that are over 60. So I would encourage anyone who's over 60 to call, but it is possible that they'll be told that they're over income. Are there any other questions?
No, that's it. Thank you.
Okay, thank you. Okay, so moving on then, I'd like to talk next about how property actually transfers at death, because there are a lot of ways that property can transfer, and so this is sort of, I think, the biggest part of the presentation. So you have to look at the deed, if you don't already know this, to see exactly how title is held, because the deed will say if title is held in joint tenancy, in tenancy by the entirety, or as tenants in common. For joint tenancy, the deed has to actually specify that property is held as joint tenants and not as tenants in common. If it doesn't have this language, then it's not joint tenancy. You can never just assume that it's joint tenancy, because it has to very clearly specify that. So if it is held in joint tenancy, what that means is that there's the right of survivorship. And what that means is that if one of the joint tenants dies, the entire interest in the property automatically, passes to the other joint tenant or vests in the other joint tenant. So with joint tenancy, there's no need to go to probate court. It's not even governed by a will. The other tenant that's on the deed, or the other owner that's on the deed, automatically gets the full interest in the property. Or if there's three people in joint tenancy, then the other two, automatically get the entire interest of the property. So it's not governed by a will. So even if the person that passes away has a will saying, I want all of my stuff to go to my kids, if the property is held in joint tenancy with the wife, the property passes only to the wife because she has the right of survivorship. But one thing to look for, though, is whether the joint tenancy has been severed. So if you look up, if you do a title search, which in Cook County, it's on cookrecorder.org, or it might be actually cookrecorder.com, but you can look up the title. And if you see any deeds after the deed that established the joint tenancy, it's possible that the joint tenancy was severed. Because in joint tenancy, the joint tenancy is only preserved if all of the joint tenants together convey the interest. If they want to, add somebody else to the title, all the joint tenants together have to add someone to the title. So if one joint tenant just kind of goes rogue and says, oh, I'm going to add my child to the title, that means that it's no longer a joint tenancy, even if the deed says joint tenancy, if that makes sense. So a second way of owning property is tenancy by the entirety, which is similar to joint tenancy, but this is only available to spouses. And again, just like with joint tenancy, the only way you can have this is if the deed very clearly specifies that property is held not as tenants in common, but as tenants by the entirety. So if it doesn't say that on the deed, then it's not tenancy by the entirety. It's not something that's automatic just because the people are married. So it's very similar to joint tenancy in that there's right of survivorship. So if one spouse passes away, the other spouse automatically has full title interest in the property. The difference is that there's an additional protection, which has to do with creditors that might, try to foreclose on the home or file liens against the home. And if the property is owned by tenancy by the entirety, and the debt is only against one of the two spouses, then that cannot attach to the home. It can't be, they can't recover against the home. So it is a protection, and again, it's only available to two spouses. And then the third way of owning property is tenancy in common. And this is kind of the default type. So if the deed doesn't say joint tenancy and it doesn't say tenancy by the entirety, then that means that it's tenancy in common. And also if it was a joint tenancy, but then you look and you do see that the joint tenancy was severed because, the wife went and added her sister to title, or something like that without including the husband on, in that and getting his signature on the deed, then if the joint tenancy is severed, then it's also tenancy in common. And so really what tenancy in common is just simultaneous ownership of the property. There's no right of survivorship. So this means that if, husband and wife are owning the property as just tenants in common, if one, it's like they each have a 50% share. So if one of the spouses dies, then that spouse's share passes, according to who their heirs are, not necessarily to the other spouse. And obviously the other spouse is going to be one of the heirs, and so they're going to get a share of that half interest, but the other heirs will also have a share. Or if there's a will, then what the will says would come into play here. Whereas again, with joint tenancy, it wouldn't. So do we have any questions, I guess, so far as those three types of tenancy? If not, we'll keep going.
Remember that you can write your questions in the window if you have anyone.
So I do have a couple other slides just giving some examples here. So I'll keep going, and if you do have questions as we're going along about the differences between these tenancy, go ahead and put your question in the window, and I'll answer it, in a few minutes. So just as an example, if husband and wife are joint tenants or tenants by the entirety, and you might see this scenario sometimes where each spouse has heirs or children from a prior marriage. So say in this case, the husband has two sons that were from a prior marriage, and the wife has two daughters that were from a prior marriage. If the husband passes away, in this case, there's joint tenancy or tenancy by the entirety, either one. So the wife takes full ownership. And how this might affect things is that eventually, the wife is going to pass away, and at that time, the property would pass to her heirs, which are going to be her daughters, and not, his sons from a prior marriage. So his sons could end up getting nothing. So this might be something that, the husband and wife didn't think through initially, that, depending on who passes away first, their own children, might end up with no share of the home. Whereas the difference is that, this is the same situation if the husband and wife were tenants in common instead of joint tenants. And the husband, again, has two sons and the wife has two daughters. And this time, if the husband passes away, the wife still has her 50% share that she had previously. The husband's 50% share, there's a typo here actually, that it doesn't just go to his sons. His 50% share is going to go, both to the wife and to the sons. So then eventually, the wife passes away, her daughters are going to split her share, but the end result is different because his sons are actually going to get their share. So it's something that they might, not have thought through at the outset. Okay, so wills and intestacy. Intestacy, as I'm going to explain in a minute, is what happens, how property passes if there's no will in place. So again, whether there's a will or whether intestacy applies, it only applies if the property is held in tenancy in common, or if the joint tenancy has been severed. If there's joint tenancy or tenancy by the entirety, that's how title passes. But if there's not, then we look to whether there's a will or what the laws are intestacy would say. So if one tenant in common passes away with a will, then that person's share is going to pass according to their will. If one of the tenants in common passes away without a will, then the laws of intestacy are going to come into play. And so the laws of intestacy, if you guys want to look this up, you can Google this Illinois statute that sets out, if somebody doesn't have a will, how does their property pass? And basically what it says, at least the most basic parts of it, are that the default rule is that half of the property goes to the spouse and half of the property goes to the children. But if there is no spouse, then 100% of that person's property goes to their children. Or if the person is married but doesn't have any children, then 100% of the property is going to go to the spouse. And then if the person is not married and doesn't have any children, property passes in equal parts to the person's parents and siblings, with a double portion going to the surviving parent if there's only one. And then also with shares going to the descendants of the sibling if one of the siblings has passed. So I feel like I see that situation a lot. If there's, maybe 3 or 4 siblings and one is passed, the person will tell me, oh, I only have, 2 siblings. But you really have to ask, well, did you have any other siblings? Because if they do have a deceased sibling, then the descendants of that deceased sibling get to split that sibling's share. So just because a sibling passed away doesn't mean that, the other 2 siblings just get the whole share. Okay. So I have a couple of hypotheticals to go through just to kind of apply this. So if Wendy and Tom are joint tenants of their home, they're married with 3 adult children, and then Wendy passes away, what share goes to her children. So in this case, oops, let me go back. I'm sorry, I don't know where my answer went here. But in this case, the children's share is nothing at this point because there's a joint tenancy. So since they appear to be Wendy's children as well, eventually if Wendy passes away, the children will have a share, but when Tom passes away. But at this point, when just the first spouse passes away, the children get nothing. The other spouse has the full title interest. Okay, so my second hypothetical, Wendy and Tom are again married with 3 children. This time they are both on title, but the deed doesn't really specify how they're holding title. It doesn't specify joint tenants and doesn't specify tenancy by the entirety. So now if Wendy passes away, what share do her children have? And so here, and getting into the math is not as important as understanding the concept, but what happened here is that since the title doesn't specify joint tenancy or tenancy by the entirety, Wendy and Tom kind of each have a simultaneous co-ownership of 50% each. So when Wendy passes away, her 50% interest passes to her heirs, which means that her husband gets 25% and her children get the other 25%. But she has 3 children, so those children have to split that 25%. And so right now they each have an 8.33% share. So this is a kind of a more difficult hypothetical that, again, it's more about understanding the concepts than, getting into the math of it. But assuming Wendy and Tom are married and are entitled to their home as joint tenants, and they have 3 children, but then unbeknownst to Tom, Wendy goes rogue and she adds her sister on the title by executing and recording a quitclaim deed, transferring it to Wendy, Tom, and her sister as joint tenants. So what she probably thought she was doing here, if she didn't have a clear understanding of the law, was she thought she was just adding the sister to title so that it would be the 3 of them on title. But really what she did is she severed the joint tenancy by adding the sister unilaterally. So when she did that, there's no longer a joint tenancy at all. What she created instead was a tenancy in common where, Tom has his half interest. She has a half interest, but she chose to transfer her half interest to the 3 of them, to Wendy, Tom, and the sister. So if you look at the math here, Tom has a half. So Wendy passes away. Tom has his half, but then he also, has a sixth, which is, a third of what Wendy transferred to him, since Wendy took her share and transferred it to Wendy, Tom, and the sister. But then on top of that, once Wendy passes away, he gets part of her sixth, which is going to be a half of her sixth. So the answer to the question is basically that he has a 9/12 share. And again, the math is confusing, but the important thing, to take away here is that if you see a quitclaim deed that's not signed by both the joint tenants, then that severed the joint tenancy, and it's become a tenancy in common. So do we have any questions at this point about these different types of ownership?
No, we don't have questions here in the windows.
Okay. So I'm going to go on and talk about when probate is needed. So again, some people have, the misconception that if they have a will, their heirs get to avoid probate, and that's not entirely true. I mean, it is good to have a will. It avoids a lot of the, more difficult parts of probate, but you still do need to file probate if you have a will. So probate is needed for wills and also for intestacy to pass property, basically anytime that there's not a joint tenancy or a tenancy by the entirety, and also if there's not a toady. So again, this is why, toadies are important, why it's important to call LAF's ADAPT project and get an appointment to get a toady, because that will save your heirs the hassle of having to go to probate court. So basically, probate takes at least 6 months, sometimes often longer. Often it takes up to 2 years to complete the whole process of probate. But for our purposes, I know that, the issue that we're working with a lot is that we're trying to get loan modifications for heirs. You don't have to wait the whole 6 months or 2 years to get that process started. The mortgage servicers generally will work with you once the client has what's called the letters of office, which only take about 30 days to get. So basically, once you file probate and go to court the first time, you can get the letters of office, and you can at least, try to modify the loan, try to assume the loan, try to work with the mortgage servicer to keep the home. So I'm going to go through just vaguely what the probate process looks like. And just in full disclosure, I'm not an expert on the probate process. I'm not a probate attorney. We're consumer attorneys, but we have co-counseled some cases with probate attorneys, and learned a little bit about the process that way. So if you have detailed questions about the process, I'm not the person to ask, but I can, give you an idea of what it's going to look like and when it's going to be necessary. So the first step of probating a will is that you need to file the original will. And if the original has been lost, there is a way that you can, petition for, leave to file a copy of it, but it's, an extra step and an extra burden. So it's important that your client has the original copy of the will, and that gets filed. And then once that's filed, or the same day that it's filed, you file a petition for probate. Once you do that, you have to send 30 days notice of the petition out to all the heirs. So really the important thing for your clients to know, if they're filing probate, is that they need to have ready the names and address of all the heirs. So again, that could mean, nieces and nephews that they haven't talked to in a long time, or, sometimes it's like a second marriage where it's, the deceased spouse's nieces and nephews that the second spouse was never really that close to. So sometimes getting the names and addresses of all the heirs, takes time, and that's one thing that you can, encourage your clients to prepare. So when you file the petition, you'll be given a court date, which is usually about 30 days out or so. So then you'll go to court on that date, and hopefully, as long as you have kind of all your ducks in a row, you'll get the letters of office on that date. And the letters of office are what say that the petitioner has been appointed the executor of the estate. And so they're kind of in charge of the estate at that point, throughout while the probate case is pending. And so again, once you have that document, that's what we found that the mortgage servicers really want to see as far as considering an application for a loan modification. But once you have those letters of office, you again need to send notice to all the heirs and the legatees of the will. You have to send notice that you've been appointed the executor of the estate. Obviously they have the right to come in and object if they don't think you should be the executor, or if they don't think the will is valid. They're allowed time to do that. If it has been less than 2 years since the death of the person, you also need to publish notice to notify any creditors, so that the creditors have the right to come in and file a claim against the estate if they want to. So that's why I say that it's going to be at least 6 months and up to 2 years to have the whole process completed. So eventually, to complete the process, you're going to record a document that's called the release of the estate's interest, and this gets recorded with the recorder of deeds, and it's what actually shows that title has passed, according to the will. So title technically vests at death, and there's case law, to support this that we've used, as far as advocating with mortgage servicers, that you don't have to wait for this recorded release of the estate's interest. You should be able to, once we have the letters of office. But it is important to eventually get this release of the estate's interest so that you can have something formal that shows that title has passed. Okay, so the probate process without a will. So I'm going to pause here because it looks like we have a question about toadies. Toadies are what I mentioned on one of the first slides, which is, it stands for transfer on death instruments. And that's one thing that LAF can prepare for your clients if they live in Cook County by calling that number on the flyer. And the transfer on death instrument is just a piece of paper that basically says, I am going to transfer my property. Sorry, on my death, I want my property to transfer to the following people. So it allows someone to explain, what they want to happen with their property, and then, since it's recorded with the recorder of deeds, that transfer happens automatically on death. So there's no need for probate. So it avoids the need for probate. So I think there's a question about whether a toady is necessary for each property that's owned, and it's not. A toady is actually a really new thing. It's only been around for a couple of years. But if you don't have a toady, then, unless the property is held in joint tenancy, the property is going to need to go through probate eventually. So toady is a way of avoiding that. Okay, so if there's any other questions, again, feel free to keep putting them in the chat box. I'm just going to run through what the probate process looks without a will. It's pretty similar. This time, the first thing you file is your petition for probate. You don't file, obviously a will or anything like that because there isn't one. Again, you mail notice of the petition to all the heirs. And then you go to court at the court date, which is, again, about 30 days out. You get the letters of office, very similar to, like you do when there's a will, except this time the letters of office will say that they're appointing the petitioner to be the independent administrator of the estate instead of the executor. So it's similar, but different because there's no will. So again, at this point, you send notice to all the heirs. And you also have to publish notice to the creditors if it's been less than 2 years since the death. And then once the requisite periods of time have passed, which could be 2 years, could be less than 2 years, you record the same document, the release of the estate's interest, to show how property passed. But here it's going to show how property passed according to intestacy, as opposed to whatever the will says. So with a will, a person can say whatever they want. They could, give the property to their neighbor, whoever they want to give it to. But if there's not a will, then, you have to look at the intestacy statute that I had on the other slide to see who the heirs are. So we've been talking a lot about the letters of office, because this is kind of this magic document that the mortgage servicers need to get. So one question is your client really the person that should be getting those? You might have, a nephew that comes in and, says he wants to save his uncle's home and that he's living in it. But, you're kind of like, well, does the uncle have kids? Does anybody else want the home? You want to make sure that he actually has the right to be there and is the rightful person. And so the Illinois law sets out this order for who should have the letters of office, going first to the surviving spouse, next to the legatees or whoever is in the will, then the children of the decedent, the grandchildren, the parents, then the brothers and sisters, and then the next of kin. But the important thing is that it could also be a person nominated by any of these. So if there's a child that's, in California and just says, I don't want anything to do with this property, they can, if they're agreeing that they'd rather have, the nephew be in charge of getting the property and whatnot, that's fine. But you just kind of want to make sure that that's the case and that there's not, some child that's fighting with the nephew over the same house. So one situation that we run into a lot is that your client is not the only heir or legatee. I've had spouses, I guess maybe more so children come in where, I have the daughter come in and she's trying to save the mother's house, and the mother passed away, and she was living there with the mother and taking care of the mother, and she's always been in the house, and she has this brother who lives far away and hasn't really been involved, but the mother left a will giving the property to both of her children. So sometimes in that case, if you talk to the client, it turns out the brother, really doesn't want the house and doesn't really have any interest in it. And if that's the case, what you need to do is get a quitclaim deed from the brother, just giving his interest over to the sister. And you can do that, regardless of whether there's a will. It's just a good way of, making clear that that person's out of the picture. They don't want the property. And obviously, it's completely up to them if they want to sign that. If you can't force it if they're not wanting to do that. But one conversation to have if there are other heirs or other legatees, other family members in the picture that are saying, oh well, I don't know if I want to relinquish my interest in this property. I think I want to save the property too. Well, if there's a mortgage, then they also are going to have to share some of the responsibility for that. So they'd have to, generally what's required is that they would have to sign a loan modification if a loan modification gets offered, which makes them personally liable on the loan as well, even if they're not living in the house and your client is the one that's taking responsibility for making the payments. If the other family member is on title and has to sign the loan modification, they're going to be personally liable. And they might also have to cooperate with the application for a loan modification and provide proof of their income and everything. So if they're saying that they want to keep the house as well, even though they're not living there and haven't really been as involved, your client will have to have a conversation with them about, well, are you willing to help me with this financial obligation? Okay, so this slide is just kind of a recap of the different ways that property can transfer. So a toady is just one way that a property can transfer. It's a simple piece of paper that gets recorded with the recorder of deeds, stating how the person wants the property to transfer. And then when the person passes away, all that needs to be done is that the heirs record a document with the recorder of deeds saying, okay, this person has passed away, and so these people are now the owners of the property. So it's really the simplest way for property to pass and avoids the need for probate. Joint tenancy or tenancy by the entirety also avoid the need for probate as long as the tenancy has not been severed. One other way that we sometimes see property held is when it's held in trust. If it's held in a trust, there's no need for probate. But as far as trying to get a loan modification or trying to pay off a mortgage, it's going to have to be removed from the trust in order to get the loan modification and to record the loan modification. So there's going to be a fee to, remove the property from trust and then put it back in trust again later if they want to. And then there's also, some fees for maintaining the trust. But again, that's another way that avoids probate. So if neither of those three apply, if there's no toady on the recorder of deeds, if there's no joint tenancy or tenancy by the entirety, and if the property is not held in a trust, then probate is probably going to be needed. So again, there's probate of a will, or there's probate without a will, which is where the laws of intestacy apply. Okay, so there's a question about if there's an option for a bond in lieu of probate. The probate actually requires payment of a bond in most cases. There's some ways to waive that. We've been able to waive that with a lot of our clients, but I believe that, probate requires payment of a bond, so I don't think there's an option for a bond in lieu of probate. I think they're tied together. I'm not sure if that answers the question. Are there any other questions about any of this at this point? Doesn't look like it.
No, we don't have any other questions.
Okay. Okay, so I just want to talk a little bit about the protections that are in place that do give rights to heirs as far as keeping properties and modifying mortgages. So what the heirs, they don't have to. One option for the heirs to keep the mortgage is to assume the mortgage. And assuming the mortgage means that the mortgage is basically changed to the name of the heirs, of the children of the borrower, instead of the borrower's name. And so they don't have to do this. So it can actually be dangerous to do this because it does give the heir personal liability. If the heir chooses not to assume the mortgage, they're not going to have any personal liability on the loan. What's kind of annoying is that the loan stays in the name of the deceased borrower. And I found, you might have seen as well, that a number of my clients get, really offended by this. They don't want these statements coming, in the name of estate of, their deceased father or deceased husband. It could really bother them. But if they don't assume the mortgage, that's the name that stays on all the loan statements. The other downfall of not assuming the mortgage is that we found that sometimes, once the loan goes into a default, a servicer just refuses to talk to the heir. Even if the heir, has been paying the mortgage for years, since the person passed away, once there's a default, it seems like the mortgage servicers just, refuse to give them any information or talk to them at all and require them to, try to assume and modify the mortgage. But assuming the mortgage is not required, so if the mom has passed away and the children are living in the property and have managed to just keep up with the mortgage payment and they're current on the mortgage, and they're okay with the statements coming in the mom's name, it's okay for them to just not assume and just keep paying the mortgage as it is. And it's actually better for them in that, they avoid the personal liability. So if, they ever were to default, the mortgage servicer could foreclose on the home, but they couldn't come after any of the children personally because they haven't signed the loan. So there is a benefit to doing it that way. It's really up to the client. So the question becomes, does the client have a right to assume? Because, sometimes once the loan goes into default, then the servicer is going to say, okay, we're not going to talk to you anymore. We're not going to modify the loan for you because you're not on the mortgage. But there are a lot of arguments that support that the heirs actually do have a right to assume the mortgage. So looking at just the principles of contract law, the general rule is that contracts are freely assignable. So that should mean, that, the mom should be able to just transfer the mortgage to her children. But the mortgage lenders kind of have an argument against that because they want to see that the person who's assuming the mortgage has creditworthiness. So they don't like the idea that, they'll screen you to see if you're eligible for a mortgage, and then you'll just decide, okay, I'm going to transfer the obligation of this mortgage to my friend when they don't know anything about your friend, and your friend, might not be responsible at all or have good credit at all. So because the mortgage lenders kind of have this interest where they want to see credit worthiness, mortgages have what's called a due on sale clause. And the due on sale clause allows the mortgagee to accelerate the mortgage and demand payment in full in the time that a property is transferred. So this basically prevents you from being able to just transfer the property to your friend and transfer the mortgage to your friend, because it gives the mortgage company the right to, accelerate the mortgage and say, no, the mortgage is due in full at this time, instead of allowing the free transfer.
We have a couple of questions here.
Okay. Let's see. Okay, so it looks like the first question says, if an heir makes payments while not assuming the mortgage, how do they refinance? So that's the problem, is that they can't really refinance. So the downfall of just making payments on the mortgage is that you're not going to have the options to refinance. You're not going to have the options to modify the loan. And that's why you might need to just assume. You would need to assume the loan before you could refinance. Second question says, what happens when the property is paid off? Can they sell? So yes, I mean, that's why you really have to look at this in a case-by-case basis, because if the mortgage is really close to being paid off and the children have been able to just stay current on the mortgage, there might not be any need for an assumption, because, if the children can just pay off the mortgage, then the mortgage gets released from the title. Well, I guess they can't sell at that point because, they still have to deal with the title issue. But as far as paying off the mortgage, yes, the children could just pay it off and be done with the mortgage. And then as far as selling the property, we would have to go back to looking at the title and how it was held, because obviously you have to be on title to sell a property. So if there was a will, the kids would have to file probate and probate the property at that time before they could sell it. If there wasn't a will, they'd have to, apply the laws of intestacy, or, again, so we would have to look back at how the property was held and get title, to be able to sell it. But yes, heirs can pay off property without having to, if they can pay off the mortgage, there's nothing preventing them from doing that. And then also the third question is it legal for the bank to call the note due if the owner is deceased? So that's kind of exactly what these protections are kind of getting at, is that it used to be that, the banks would just automatically call the notes due. And there are now some protections that protect against that, which is exactly what this slide is. So Garn St. Germain is a federal law that protects lenders by allowing due on sale clauses, but only with a few exceptions. And so these are the exceptions where there can't be a due on sale clause. So a lender can, put a due on sale clause, that prevents you from being able to just, transfer the mortgage to your friend. But if there's a transfer on death to a joint tenant, or to a tenant by entirety, or to a relative, or to a spouse or children, which is, I think, what this question is getting at, lenders are not allowed to enforce due on sale clauses in those instances. So basically, they have to respect those transfers. The same thing happens with a transfer that's part of a divorce. So basically, if Garn St. Germain is applied, then the due on sale clause, cannot be invoked, and the mortgagee or the lender cannot accelerate the loan, and has to allow an assumption, given that one of those exceptions applies. And the rationale behind this is that not allowing an assumption in those circumstances is just completely unfair and inequitable. So basically, if your client falls into one of these four categories, they are protected in the event the mortgage borrower passes away. Enforcing this, I think, has been, more difficult. I mean, the law is really clear, but, we've had to really advocate in the courts to force the banks to respect it. So it might be a situation where you do have to refer your clients to an attorney or to LAF or to your local legal aid for help. But you should, know that this law is out there, that if they fall into one of those exceptions, they are protected. So the CFPB, the Consumer Financial Protection Bureau, has also passed some rules recently that are similar in that they protect the heirs of borrowers. A few years ago, they passed a rule that says that lenders are not required to follow the ability to repay rule where a successor in interest agrees to assume. So it's kind of, a loose rule. It's not as tight as we'd probably like to see it, but it says that the lenders don't have to look at the credit worthiness of a successor in interest. The new rule that's not yet in effect, though, is much better, assuming that nothing prevents it from taking effect. It's scheduled to take effect, I think, in April of next year. And this actually puts an affirmative duty on mortgage servicers to look at the status of a successor in interest and see if they're one of the Garn criteria. So the mortgage servicer has to, if someone's passed away, the mortgage servicer has to look at, who's in the house, who's trying to assume the mortgage. Are they one of these 4 exceptions? And if they do fall under one of the exceptions, then that heir or that spouse or divorced spouse is subject to all the same protections that the borrowers are subject to. So basically, RESPA and TILA, and that includes the relatively new loss mitigation rules under RESPA that require mortgage servicers to consider loan modifications as long as they're submitted 37 days prior to a sale, and it requires the mortgage servicers to postpone the foreclosure sale if there's a pending application for loan modification. And there's a lot of really important protections basically that apply to heirs and successors in interest as long as they fit within one of those 4 Garn exceptions. But again, this rule is not yet in place, and hopefully nothing will stop it from being put in place. Okay, it looks like we have another question. Can the servicer condition a Garn assumption on creditworthiness or application fees? Yes, I'm not sure about application fees. Basically, what we're seeing happen is that the mortgage generally falls into default or is at risk of default after the borrower passes away. So the heirs will simultaneously apply for an assumption and a loan modification. So obviously, if they're trying to modify the loan, they do have to look at creditworthiness. If the loan is current and they're applying for only an assumption, I'm not sure if they've been looking at creditworthiness or not. But I think that the CFPB rule supports that they wouldn't have to. But again, it's not as strong as we'd like to see, saying that they can't. So yeah, I'm not sure if they would look at creditworthiness or not. And as far as application fees, I haven't seen. We've helped some clients with assumptions in conjunction with loan modifications, and I haven't seen anyone be asked for an application fee for that. It might be that there's some kind of fee worked into the loan modification that goes on the end of the loan, but we haven't seen any kind of upfront fee. So this is just a list of the different protections that are available. So again, there's the Garn St. Germain is the federal rule. It's been in place since the 80s, and so that's a really important thing to know about. The CFPB rules, and then if you're working with a client that has a Fannie Mae loan or a Freddie Mac loan, both of those have servicing guidelines that are similar to the CFPB rules and Garn St. Germain that protect heirs. So you should look up, respective to whichever you're working with, you should look at those as well. The FHA rules, I have the site for it there. I think the rules actually say that that all mortgages are assumable. And so there's definitely protections there as well for heirs, being able to assume mortgages. I just want to mention that bankruptcy can also be an option, even if the client doesn't fall into one of the Garn exceptions. One option might be that your client lived, with a partner who lived with the deceased person for several years and lived in the house and helped pay for the house, but they just never got married. In that case, Chapter 13 bankruptcy might be an option because there are some arguments that you can make to the bankruptcy court that you should be able to, assume the obligation. So just going through the steps to helping your heirs save the property. The first thing to do is look at a deed to see how it's held, because if it's been held in joint tenancy or tenancy by the entirety, property automatically passes to the joint tenant. That's one of the categories in Garn, but it almost shouldn't even have to be, in that, it's very clear that that person is already on the title. If there's not a joint tenancy or tenancy by the entirety, you should look and see if there is a toady. You're probably not going to see a lot of toadies recorded yet because they are so new. So it's something that I would encourage you to push on your clients or inform your clients about. But you're probably not going to see a lot of them yet. But if you do, then property passes according to the toady. If not, then your client will have to file probate before they could try to modify the mortgage or assume the mortgage. If they're having trouble doing this, at least at the Daily Center, there are help desks that have been successful in helping the clients to file probate pro se. Again, the biggest thing is that the clients are going to need the names and addresses of all of the heirs and anyone named in the will to send proper notice. I think with probate, the biggest thing the judges are going to be concerned about is that everyone is getting notified. So that's one thing that you can have your clients prepare. And then once you have the letters of office, which again should only take 30 days from when you file the probate, that's when your clients can apply for the loan modification and assumption. They can apply for those both at the same time. And we're finding that servicers pretty much require those to be applied for at the same time. They don't really want to see one without the other. But we would really encourage you to call LAF if you're running into issues, at any of these stages. We have gotten involved in a lot of these cases, and I have the last slide here. I have my direct phone number and email, as well as my supervisor's direct phone number and email, because we would welcome, direct referrals from you guys if you're seeing, cases where these protections under Garn St and Germain are not being honored. Definitely let us know about them. We might be able to get involved. We have been able to co-counsel probate cases in some, in some cases. So basically, if we think that we would accept the foreclosure case anyway, then we might be able to take the probate case. We can't do probate just to do probate, but we might be able to if we would take the whole case. So I would really encourage you to send us your cases. And I just want to mention one more time that divorce and divorcing spouses are one of the categories under Garn. And I think this is important. There's also, rules within the Fannie Mae and Freddie Mac guidelines and within the FHA rules that also give protections to them. Because some divorces just take so long, it can really be a problem that, the default on the mortgage is just so big by the time that the divorce is finalized. So it might be something where, you really need attorney involvement. We've gotten involved in these situations, so feel free to contact us. But that's pretty much all that I had. Do we have any other questions?
No, not at the moment. We don't have here more questions, but this is the information. You see the email for Katie. Mm-hmm. So thank you so much for great questions, for your participation. I'm going to send you the link after this afternoon. I will send you the link of the recording webinar. Thank you so much for attending. Thank you, Katie, for a great information, and I hope you can join us soon again. Have a wonderful day.
All right, thank you.
Okay, bye-bye.
Bye.